They want to interfere in
Please, Chogadda, please. The historical development of Waqf legislation in India, from the Bengal Waqf Act 1934, Uttar Pradesh Muslim Waqf Act 1960, the Waqf Act 1954, and the subsequent unification under the Waqf Act of 1995, has always retained the sanctity of the term. These laws, while designed to provide statutory governance, have consistently respected the essence of Waqf as a concept grounded in Islamic law. Madam, insertion of clause 2A. Insertion of clause 2A tantamount to nullify and all earlier judgments, degree and orders of any court in respect of the Waqf and the trust. This attempt is basically taking away the rights of the Muslim, which they have accrued. Any attempt to nullify the Supreme Court judgment by legislative process is illegal and unconstitutional. Clause 3 Roman 9 of the proposed bill that said various sects and subsects have been created. This attempt to create subsect without having any rational object is not a good sign for any religion, caste or creed. If the constitutional provisions empowers the parliament to create caste, subcaste or subclause, only then the parliament can do so. Like the scheduled caste created inside Hindus, but the constitutional provision does not empower the parliament under the guise of the Waqf Amendment Bill 2024, create Aga Khani Waqf, Bora Waqf, etc. The intention to legislate such kind of classification of Waqf board based on subsects, the ruling party in the government is having evil intention. If the title speaks about unification, creation of various Waqf board on the basis of subsect itself creates a de-unification between the sects and subsects of the Muslims. Madam, clause 3FA of the said proposed bill defines government organization including municipalities and panchayat and autonomous bodies of the state and central government to a part 9A of the constitution. Under the scheme of part 9A, the municipalities and the panchayats are self-government and autonomous bodies. How the properties of the self-government bodies can be treated as a government properties, madam? In a constitutional provision it has made it. By this law, panchayat and municipality has been described as a government properties. It is not a government properties, local self-government bodies. Therefore, there is a distinction. Therefore, this provision is bad. Madam, introduction of definition of the government property seems to be mischievous. Why Waqf will be allowed to define government property? This is an attempt to legalize illegal occupation or Waqf property by government organizations. Another sin is there. In our JPC, we have said repeatedly, give us the data what the government has occupied the property. Nothing is there. And in Rajasthan, it is a case, is extreme cases. 80% of the property of the Rajasthan, Waqf property has been occupied by the Rajasthan government itself. Practicing Islam for at least 5 years is a precondition for making Waqf is thoroughly unreasonable, irrational and manifest arbitrary. Under the scheme of the Constitution of India, no person can be compelled to practice his own religion. If no person can be compelled to practice his own religion, then such persons cannot be debarred either to offer his property to God or whether he is Hindu or Muslim or any other religion. Practicing religion means day-to-day performance of his religious duty. In a secular democratic country like us, no one can compel to perform any religious duty. If such a provision cannot be made either in the Constitution or in any other statute, no mandatory provision can be made for practicing Islam for at least 5 years for making Waqf. Even if I discharge my religious duty on my own at any place, I cannot be compelled to speak whether I am performing religious duty or not performing the same. Who is anyone can ask me whether I am performing religious duty or non-religious duty? Is it not a violation of a constitutional right? What the Constitution has given you the power to say, to ask me the question, I am discharging religious duty or not discharging the religious duty? A man can believe in performance of religious duty at any point of time of his life, any point of time, before death even. Performing of a religious duty cannot be the basis belonging to that religion. Even in a Hindu mandir which is governed by an act, like Puri Jagannath temple or Kashi Vishwanath temple, there is no such provision that any person practicing Hindu for at least 5 years and then only can donate anything to the deity. Madam, I can't donate. If I want to donate, it's my choice. How my choice can be controlled? I can donate to Hindu mandir. I donate to everywhere. I donate in Hindu mandir. I donate in Muslim property. I donate in the Christian property. I donate in the Buddhist property. I donate everywhere. I donate beggars. I donate everywhere. How can you control this act? How can I control? By reason of insertion of this clause, no other person of a religion can make over any property to Waqf. The proposed amendment is thoroughly misconceived, arbitrary, irrational, and therefore violates Article 14 of the Constitution of India. Under Clause 3, Roman 9b, existing Clause 3R1 has been omitted. That means Waqf by user is being taken away. Waqf by user is a long-standing practice of Muslims. In our country, Waqf by user is a very common practice, and decades after decades, rather time immemorial. Waqf by user is a practice. The concept of Waqf by user was recognized in our country in the case of courts of words for the property of Magdam Hassan Baksa versus Illahi Baksa and others, 1912, SCC online, page 45. Madam, the Honorable Apex Court in the matter of Sayyid Muhammad Salih Labbai, dead by Eller and others versus Muhammad Hanifa versus Eller and others, 1976, 4 SCC 780. In paragraph 34, 36 and paragraph 39, categorically accepted this Waqf by user. The necessity is necessary in case of prayers offered in congregation. A single Muslim can also offer his prayers with or without an imam, but if prayer is in a congregation of a Jannat are offered only behind an imam who leads the prayers. And Islam is an extremely modern and liberal religion. There is no question of any person being denied admission in a mosque for the purpose of offering prayers, and that is why the law is so strict that the moment a person is allowed to offer his prayers in a mosque, the mosque becomes dedicated to the public, and therefore it's an Waqf property. Therefore it's an Waqf property. Finally, it is not necessary for the dedication of public mosque. Thus, Madam, in that judgment it has said, so that when a person erects a building with the object of dedicating it as a mosque and permits people to offer prayers therein without declaring that he has constituted it into a mosque and prayers are offered, there bil jammat, the mosque becomes irrevocably dedicated. It is dedicated. Madam, I just give one instance. In the Raishina village, where the residence of the President of India is there. It was a long back, it's a big village. In the big village, there are so many Muslims are there. One Hindu dedicated his property for offer their namaz. And that is the property, that is the mosque is in front of the parliament. In the front of the parliament. Who has not come here? All. Abdul Kalam Azad. So all important political leaders, including Bhutto, and the Imam of that is sitting here as one of our colleague, member of parliament. If prayers are offered once in a mosque, it is sufficient to constitute a good dedication. Dedication has been clearly said. Paragraph 39 of the judgment, that the founder must declare his intention to dedicate a property for the purpose of mosque. No particular form of declaration is necessary. The declaration can be presumed from the conduct of the founder, either express or implied. If this is the principle of law, is long-standing in our country, how can you say today you have to register Waqf by user? You have to give a declaration. I don't need to. Therefore, you are trying to, by this bill, you are trying to take away the basic reason of all the judgments of the Supreme Court. This is not correct and this is bad. Madam, neither a document nor express words are essential for dedication of religious or public purpose in our country. Such dedication may be implied for user permitted for public and religious purposes for sufficient length of time. The conduct of those properties is presumed to be dedicated to for religious. It has been said by Sri B.K. Mukherjee on Hindu law. Sri B.K. Mukherjee on Hindu law of religious and charitable. I do not think that anyone in India is here now. Or today, in India, there is anyone who understands Hindu law better than the B.K. Mukherjee. No one. He has said so in his book. Anyway, new concepts, smart mans have come like a smartphone. Therefore, everything is being done. In the case of M. Siddiqui, through Elash vs. Mahanath Suresh Das, 2021 SCC page 1, it has expressly said Waqf by user. Our jurisprudence recognizes the principles of Waqf by user, even absent an express deed of dedication. This is being taken away. Now, long judgment I will not read. This is being taken away by this. Therefore, it hits the basic things. Clause 3, subclause 5 of the said proposed bill. The verbal declaration of Waqf has been taken away. This is contrary to the history of creating Waqf by any individual. Several properties are dedicated as Waqf by a good number of persons to be made as Waqf property. Madam, the deletion of the word either verbally or violates the right of the Muslim as protected under Article 25 and 26 of the Constitution. Therefore, it hits the basic structure of the Constitution.